Good morning everybody. By the previous video, we have completed up to Article 195. Today, let us study Article 196 to 199 relating to passing of bills by the legislature of a state. Article 196 Clause 1 says that a bill which is not a money bill may be introduced in either house of the state legislatures. However, money bills cannot be introduced in the legislative council. They have to be necessarily introduced in the legislative assembly of that state. In this article, first we are dealing with non-money bills. Such bills are deemed passed in the legislatures only if that bill is passed by both houses of the state legislatures, namely assembly and the council. Clause 4 says that a bill pending in the legislative council which has not been passed by the legislative assembly shall not be deemed to have lapsed even if the legislative assembly is dissolved. And clause 5 says that a bill which is pending in the state legislative assembly or which has been passed by the state legislative assembly, if it is pending in the state legislative council, it shall be deemed to have lapsed. To me, these clause 4 and 5 appear to be contradictory. Article 4 says that if a bill is not passed by the assembly which is pending in the legislative council shall not lapse, whereas clause 5 says that if a bill is either passed or pending in the legislative assembly which is also pending in the legislative council shall be deemed to have lapsed in both cases on dissolution of the assembly. I advise the listeners to refer to Article 196 clause 4 and 5. Decide for yourself. To me appears there is some confusion or contradiction. Article 197 reads, after a bill has been passed by the state legislative assembly and transmitted to the state legislature and transmitted to the state legislative council, the bill is rejected by the council, kept pending in the council for more than 3 months, or the bill is passed by the legislative council with amendments which the assembly does not approve, then the legislative assembly may pass the bill with or without modifications again in the assembly and may transmit it to the legislative council. If after passing the bill for the second time and transmitting it to the legislative council, A, the bill is rejected by the council, or B, kept it pending for more than 1 month, or the council has passed the bill again with amendments. In such case, the bill shall be deemed to have passed by both houses of the state legislatures as passed by the legislative assembly. Clause 3 says that nothing in this article shall apply to a money bill. In case of money bills, I told you they cannot be introduced in the legislative council. They will have to be introduced only in the legislative assembly. After the assembly passing such money bill, it would be transmitted to the legislative council. The council has either to pass the bill or return the bill with or without modifications within 14 days of receipt of the bill. If the legislative assembly agrees to the changes proposed by the legislative council, the bill is deemed to have been passed by both houses of the state legislature. Supposing the state legislative assembly does not agree to the amendments proposed by the legislative council, even then the money bill is deemed to have been passed as passed by the state legislative assembly. Clause 5 says that a money bill passed by the state legislative assembly and transmitted to the state legislative council is either not passed or returned within 14 days. The bill is deemed to have been passed by both houses of the state legislatures. Then a doubt should arise. What is a money bill? A bill which contains monetary matters is a money bill. Whether a bill is monetary bill or not, it shall be decided by the Speaker of the Legislative Assembly, and when sent to the assent of the Governor, the speaker shall clearly mark on the bill whether it is money bill or not. Money bill includes especially the ones relating to imposition of new taxes, abolition of the existing taxes, or altering the rates of the taxes. And secondly, anything relating to borrowings by the state and giving sureties by the state government. Third is relating to operation of the consolidated fund of the state or the current account of the state and withdrawals from the consolidated fund of the state. Usually, the custodian of the consolidated fund of the state is the governor, and if the assembly wants to declare any expenditure to be expenditure on the consolidated fund of the state, such bills also are defined to be a money bill. One exception is provided. Though it contains monetary matters such as imposition of fines, fees, cess, etc. by the states for the local bodies, the bill shall not be deemed to be a money bill. Any matter incidental to the issues we have hitherto discussed would also come under the definition of money bill. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. I will be glad to reply to your worthy comments. My purpose of starting this web series is to bring to the notice of the listeners the whole of the Constitution, highlighting wherever it was misunderstood, misused, misapplied, as a result of which the country is facing political instability, political uncertainty, political immorality, social strife and poverty. Thank you very much.